Welcome. This is Acorn Asks Attorneys, and we have invited Armstrong Law to come today. We are so excited. Rebeccah Armstrong, the managing partner, and Reagan Riddle, the partner at Armstrong Law, have decided to grace us with their presence, and they're answering our questions about the divorce process. It is a great topic because a lot of therapists do not know how the whole thing works. And also what we don't know, we don't know. And so what we're going to do is Rebeccah and Reagan are going to take turns leading us through the divorce process roadmap. And then at the end, I'm going to ask some questions, and hopefully they will be the questions you would have asked. If not, email us. You will have access to Rebeccah and Reagan as well. We'll give you their emails and their website. So if you get some questions that you know that a therapist is going to answer, then absolutely talk to them. They love therapists. I've come and spoken at their office and train them on some of the things that I know more about than they do. And that's been a real blessing. I've loved doing that. Reagan and Rebeccah, go ahead and give us this roadmap to a divorce.
All right. Well, thank you, Christy, so much for having us. And I agree. Your help, and as well as Dr. Pam's help, has been so helpful to our staff and training us, and from y'all's end of things. So we always love to hear from you and learn new things. So I'm about to share my screen, but what you're about to see is this roadmap or path forward to divorce that we created to really try to help our clients. That was the initial thought process. But since we've used it as a tool also to give to therapists like yourself, or to financial advisors, just people that are helping our clients through the process that maybe don't understand all the ins and outs. We worked really hard on this to try to help our clients visualize, okay, where am I in this process? When's the next step, or what is the next step? Why am I not divorced yet? So that we can kind of help them. Yeah, we get that a lot. I'm like, well, you're only on step 3 and we got to get to step 10. So we talk about it. We use this roadmap a lot in the consultation process as well, to kind of explain to them and take the mystery out of the divorce process. Because as all of you therapists that are watching know, the more information that you have, the less anxiety that you have, the more empowered you feel, the more informed you are, and therefore you're making decisions out from information, not out of fear. So I'll go ahead and start going through this lovely roadmap that we've created. So again, this is kind of a handout that we give to our clients, and we go through with them, and sometimes the consultation and just throughout their divorce. But steps 1 and 2 and 3, essentially the first step is always the consultation and meeting with your lawyer to figure out, okay, what's my game plan? What's my strategy? What do I need to do? What do I not need to do? So we talk to our clients about, okay, are there any safety concerns? Do we need to put a safety plan together? How is your spouse going to react? And every divorce is different. We talk to them about, okay, do we need to file first? Or is this a case where you can maybe have a conversation with your spouse, soon to be ex-spouse, and talk to them about, hey, we've both been unhappy. I think it's time that we file for divorce. So we talk to them in that strategy conference as to how their spouse is going to be notified, what makes sense. We really, at our firm, our philosophy is to try to not escalate things. And so these are 2 people that have been in a marriage, and to the extent that they can have this transparent conversation about getting a divorce instead of just blindsiding them and having them served at work. We talk through all of those different options in that initial strategy conference. So second step, that's why we have a step 2, notifying your spouse, because sometimes that is before we actually file. So we kind of talk through in our strategy conference, what's the order of that?
Can you
And
make
then,
that bigger?
yeah, let's see.
I'm sorry, I'm getting old.
It's okay.
Oh, perfect.
Okay, let me adjust it 1 second.
There we
Okay,
go.
is that good?
That's great. That's perfect.
Okay. So we talk about in the strategy conference how we're going to notify the spouse. We also talk about what is going to be filed.
Mhm.
So we talk through, okay, is this a case that can have a very simple petition for divorce, or is this something that we need to go ahead and put in some specifics for what's called temporary order request? So we'll talk about that in a minute. So we talk through all of that. So that's kind of the very first step, is going through with the clients, talking through safety concerns, communication, and really trying to figure out what's the tone that we can set for the divorce.
Mhm.
Because obviously if they're filing emergency relief because they need some safety precautions put into place, that's going to be a different tone than, hey, sitting down with their spouse and kind of talking through with them about how the divorce might be going forward. So that's kind of the very first step. So Reagan, if you want to talk about temporary orders, which I just briefly mentioned, what is that? What are temporary orders?
Yes, you don't have to have them in every case. And that's what we tell the client as well in the consultation period is, do we need temporary orders? Do we need to go before the court? Do we need to go have a hearing? And that really depends. If we have a couple that can maybe sit down at the kitchen table and have a discussion about how things are going to proceed forward on a temporary basis, like how are we going to split the bills? Who's going to live where during this time while we're figuring out our final terms of our divorce? When am I going to see the kids? Where am I going to see the kids? Those types of decisions, if you have a couple that is pretty amicable and can have that type of communication with one another, you're oftentimes not going to see them at a temporary orders hearing. They are going to agree to those temporary orders.
Mhm.
However, if we've got a high conflict couple who cannot communicate with one another, they can't agree on if the sky is blue, you're probably likely going to see them go before a court and have a judge make those decisions for them. And so in that scenario, we're going to a hearing. Your clients are going to testify in front of a judge, and they're going to hear not so nice things about them by their spouse or other witnesses, and vice versa. They're going to say some not so nice things. So it can be a particularly stressful and anxiety inducing process to go in front of the judge and have that hearing. And so hopefully a therapist is already involved, we always encourage our clients in that initial consultation, hey, divorce is hard. You know, even if you don't think you need the extra support or resources, go talk to somebody, because they can at least help you with your own decision making and trying to work through the emotions of the divorce process and separating and all of that. So hopefully you're already involved before the temporary orders, but if you hear that we're going to a hearing, if it's an initial hearing, it's likely this hearing. It's likely this temporary hearing where a court is going to decide who the schedule for the kids during the process of the divorce, where everybody's living, what bills are being paid, what money is being transferred to which party, those types of what we call band-aid issues. Like, we're putting a band-aid on things. We're trying to keep things pretty status quo until we can get to a final resolution. And this hearing is probably, if it's going to happen, is going to happen pretty quickly. Usually it'll happen within a month, maybe a month and a half of when the filing begins, because we do need to have a Band-Aid on those issues if we can't come to an agreement, especially on possession and access and where the kids are going to spend their time. So if you're not already involved in with either an individual party or a child to the case before the temporary order hearing, then a lot of times you'll be getting involved after this hearing, because one of the bigger points that a lot of times requests that attorneys will make, is that the kids need to be in counseling. Because if we're already high conflict and we're going to this hearing, kids probably need to have their own resources, their own support, because mom and dad can't get along because we're at a hearing now. And so at this point, you actually may be appointed, or a client or, a judge may award one parent or the other the right to make the decision on the child's psychological needs. And so you may be hearing from mom or dad saying, hey, I have that right, and I want to get my children into therapy with you. It's always important to make sure you get the court order when you are being appointed in an active litigation case, just so you can make sure that either you're appointed or you're being asked to treat a child by the correct parent that has the right. And what's even more confusing, sometimes both parents have the right. But either way, a lot of times you will get involved either with seeing a child or a parent either right before this hearing or right after. And that kind of leads me into the next step, which is the gathering information. So if you are involved in a case that is actively being litigated, you're also going to be a part of this gathering information section, more than likely. So this is the time when we tell our clients, hey, we need to get all of your financial information together so we can figure out what your estate looks like. So at this point, the clients are probably a little stressed out as well because they're having to pull up all of their financial records from whenever they got married forward to try to exchange that information with the other side. A lot of times we have what we call the non-moneyed spouse, maybe the spouse that wasn't involved so much in the finances for the first time, getting information about what their estate looks like. There is a lot of fear associated with learning this type of information initially for those spouses that do not have an idea of what is in their estate. And then, so you're probably seeing a lot of those fears come out in session with those individuals. And it's just part of the process of, hey, you know, you may only get 10% of the information right now, but we're still like, it is an ongoing process of getting all of this information. So part of that involves, you know, if the other side is not super cooperative of getting the information, that there'll be a lot of subpoenas being sent out to various banking institutions and or you as the therapist to get information related to the case to help support that particular person's claims. So how you're somewhat involved in it, not only from helping the client kind of come to terms with, hey, you know, this is what your financial situation may look like, and what are the realistic fears, or maybe what are the things you could be doing to alleviate those fears, whether that's getting more training or more education to get a job if you're a stay-at-home mom for 10 years, those types of things. But from the therapist's point of view, you may also be receiving subpoenas yourselves to be like giving them kiddo, you know, information or intake information from the parents. You may also be getting subpoenas for if you're a marriage counselor. Obviously, you need all the appropriate releases to be able to send those notes during marriage counseling and all of those things. But that's how you might be involved personally with the gathering the information process. But a lot of what it is really just more financial based generally.
And so on that, just one other thing I would point out is, so when we meet with our clients, a lot of times we'll talk to them about, hey, you can skip step 4, which is temporary orders. You don't have to do that, like Reagan said. And then in regards to the gathering information step, we tell them, hey, there is going to be a very limited amount of information that we 100% have to have in order to draft all the documents that are required in a divorce in the state of Texas. But you don't have to do all of these things that Reagan just talked about. You don't have to do that. You don't have to get the records from the therapist. You don't have to exchange statements back since the date of marriage or for the last 5 years. For the lawyer, all we really need in order to, if they have an agreement, all we really need is usually the most recent statements, a little bit of some identifiable information like their date of birth, driver's license, things like that. It's very minimal if they have an agreement. If they don't have an agreement, that's where all the things that Reagan just talked about come into play. So we tell our clients, look, step 4, that's a costly day. As far as your attorney's fees, when we're talking about all the options in step 5, that can be costly. That can increase your cost. So we really put that back to our client of, here's all your options. Here's kind of the costs associated with those. What do you want to do? These are your decisions for you to make. So that's again where you guys will be helping them if you're seeing them on an individual basis, is that, hey, you can make decisions for yourself. Like you've got this. All you need some information, you need some data from your lawyer, 100%, but then you are making the decision. You, the client, are making the decision. So
Absolutely.
that kind of is that's a good segue to potentially step 6, which step 6 is working with hired or appointed experts. So Reagan just talked about, okay, during the temporary orders, the court could order certain things like counseling for the child. The court could also order what's called child custody evaluations, can order psychological evaluations. If the property or the estate, as Reagan was referring to, the stuff that the parties own, if it's complicated, and by complicated, I mean if they have a family business that needs to be valued, and because one person's going to take the business and the other one is going to potentially either get assets of value that they have, or they're going to get bought out of the business by a payment plan or something like that. Regardless, there might need to be an expert to be appointed to value that asset or to do these evaluations if we're talking about child custody. So that's kind of, again, where Reagan was talking about earlier of how you guys might be involved, is that a child custody evaluation is a child custody evaluator is appointed, or psychological evaluator is appointed, then and your client is seeing you, then they're likely going to want to talk to you. They're going to see your notes as well, your records, things like that. So depending on who's been appointed, that's where you might also have some contact as well. So we tell our clients all the time, obviously that is expensive because you're talking about hiring outside professionals, but sometimes the case needs it and the parties can agree. And so that's just what we have to do. And then specifically, even when we do have a couple that are in agreement, they just may not know the value of an asset. And so we need to get a value done. We can agree to a joint expert. That saves some money as well. So where that one person goes out and appraises the house, for example. So that's another way. Then we kind of have the settlement process. So that's kind of step 7 and 8. So if Reagan, you want to talk about that for a minute.
Yeah, so step 7 would be amazing. That means that the parties have been able to reach an agreement without any type of court intervention, without any type of, so great if they can informally settle. Those are for the couples that communicate and can make decisions together and compromise. Sometimes I always tell my client, if you can't do that, or you just attempt to try to do that, if it doesn't work out, that's okay. A lot of times it won't work out. But worst case scenario, which is not a bad scenario, is we'll just go to a mediation. And so what a mediation is a more concentrated effort by everybody to sit down on usually one full day to try to get a deal done, to try to figure out and make decisions as to all of these big issues that the court would ultimately make decisions on. So custody issues, property issues, that's what we're trying to figure out and try to finalize all of those decisions in a mediation. A mediation is great because there is a neutral involved that can be a great sounding board to each party in their individual rooms. So the way that's set up typically is wife's, one spouse's attorney and that spouse are in a room separate and apart from the other spouse. We have found that putting 2 spouses in the same room is not really conducive to settlement. So we put them in separate rooms, and the mediator, who is our neutral, who's usually the people that we select and agree to, are generally, past family law attorneys or past family law judges. So they know what they're talking about. Usually they're board certified like Rebeccah and I. So you can feel confident that the advice that they're giving in each room is accurate and helpful. So that mediator, that neutral, will bounce back and forth and try to facilitate an agreement. And 9 times out of 10, they will be successful, because the alternative is to go to court, which is very, very expensive, as well as not helpful to one's family, because you're giving all of your power and decision-making rights over to a judge who is going to hear your case for maybe a couple hours, maybe hear about your family for a day. And then that person's going to make a decision that is probably, practically speaking, not super helpful to either one of you or your kids. So it is always more helpful if both parents are in the driver's seat about what is going to affect ultimately their lives and their kids' lives. And so that's why the mediation process is so great, because you can make agreements to things that the court would never even consider making agreements to. So that is why a lot of times, like, we will end up settling in that mediation process. But just to paint the picture of what that looks like for your clients, it is a very draining day. For our clients, it feels like final trial. It feels like a conclusion to their marriage. And so along with that, we have grief, and we have that realization that this is really happening, all happening in a 1 8-hour day or longer. It is just emotionally really, really difficult for them. And so coming out of mediation, I don't know one client that hasn't been absolutely exhausted. And so Rebeccah and I always get with our clients ahead of time and tell them, this is what the day is going to look like. As much, try to give them that expectation as much as possible. But at the end of the day, it's just a really draining day to go back and forth. And there's a lot of emotions are very high in this type of setting, even though they're not even in the same room. But if they can come to a resolution, for all intents and purposes, they're done. Like, if they agree and sign the agreement at the end of the day that to all these issues and this is how we're going to handle it, they are done. And it's just administrative paperwork from there, which can finally feel nice to them. They can kind of breathe and understand, okay, this is what my future is going to look like. Because up until that decision is made, whether it's by them or the judge, it's an unknown, right? They don't know what property they're going to receive. They don't know what the schedule is going to be like. So it does feel, they do feel some finality from that. And so I do think that they have a sense of relief of actually knowing what the future is going to look like for them.
And I will also, just adding to that, I will say, both Reagan and I have talked about this. I hate the way that we do mediation, of where we're cramming it all in an 8-hour plus potentially day. But the way that our family law community, and I'm talking about the legal community, it is difficult to get lawyers to focus on the case unless they're at mediation. Christy's probably laughing about this right now. So some are better.
This is why I like the collaborative law, where you do multiple mediated joint meetings across several different settings, so that there's not that
cramming it down somebody's throat. That's what it feels like. Like, you're making them, they're having their emotional reaction. They're in their fight or flight, and we're like, sorry, you got to make a decision on this right now. Like, that's what we do. And it's awful, awful, awful. But the reality is that it's difficult to get all the lawyers to get on the schedule with a mediator. And we're talking about an individual's finances. So a lot of times they don't have the money and the resources to go back a second day of mediation. And so, and a lot of times what we've seen, even when we've done that, because Reagan and I both have done day 2, day 3 of mediation, where we reset it. It's not consecutive. It's like, here's day 1 of mediation. And then, okay, well, we didn't quite work it out, so let's reset. Well, it's like reset for 3 months from now because of everybody's schedules sometimes. And so sometimes it is just a, hey, I know that this is hard, but we've got to make decisions. And so we have brought in our client's therapist, and just said, hey, can your therapist be there? Like, when we know that they're going to have a really hard time making decisions. So we'll sometimes implement that, or we'll talk about, hey, we're going to have to split this up into 2 half days. We just are, like, it's just, we're going to have to do that. So let's just go ahead and book that now. So a lot of times we do that, but we get a lot of pushback from our clients because they don't know, right? Like they don't want to spend a lot of money with us. And we're like, we get it. We want you to keep your money. But they think, oh, it'll be fine. It's like, we'll be done by lunchtime. And we're like, no, you won't. But okay. So like they don't really get it until they're in it. So we can tell them that all day long. But therapist.
I highly recommend any therapist who knows a mediator asking to go and observe a mediation and walking around with that mediator. You would be amazed at how they pace it to give the clients the time to calm between conversations. They're not just speaking with the other person in between the times that they're speaking with you. Sometimes they're taking a deep breath themselves, letting not the therapist, the lawyers take deep breaths. It's amazing how they do that pacing so that it doesn't feel so intense, but at the end it does get pretty intense. Yeah.
So we know it's a terrible process, or Reagan and I acknowledge it is a terrible process.
But it's the one
but it is what we have right now.
That's
what
the one we
happens if
have.
mediation doesn't work?
Then great question, Christy. We're about to go into the second half of the roadmap.
Oh no. And you know what we have? We've been on the phone for a while. So let's take a deep breath. Everybody do some breathing and go into the most, I have to say, aside from discovery, when I'm working with a client, this is some of the hardest times. I always, as an individual therapist or just a therapist involved peripherally in the case, like a child therapist, I tell parents, look, you think the final trial is going to be great and you're going to get justice, but that's not how family law is really set up, I don't think. And you guys can tell me that I'm wrong. But what happens at final trial is the worst day of your life.
I would agree. Reagan, you want to talk about steps 9 and 10?
Yes. So 9 is just a little hearing that sets you up for your big hearing. So it's called a pretrial conference. Before anybody has a final trial, the lawyers will go in front of the judge and have what we call a pretrial conference. And a lot of times our clients don't understand what that is. It is essentially just a scheduling day of like when we're going to have final trial, but also tell me, litigants, what you are asking me to do. What issues are before me? What have you guys agreed to? What have you not agreed to? And if you're at that pretrial conference, I bet you haven't agreed to a whole bunch. Like I bet every issue is still on the table. And that's where you're telling the judge and informing the judge in this very mini hearing what the judge is going to try. And the judge will set you for trial. And on that trial day, that you'll be going to final trial. And that could be a day, could be 2 days. It could be in front of a jury. Usually in family law, it's in front of a judge because that makes it a lot less expensive, although it is incredibly expensive either way. And typically you're in family law, we're looking at like a day, maybe 2 for final trial, depending on how many issues there are. But either way, this is the step this means we haven't been able to agree to anything. We are very high conflict. We are giving up all of our power to this judge to make all of our decisions because we can't make them. That's that step. So before we've gotten to this step, you can imagine we have had a lot of conflict because now we're here. So at this final trial step, this is a long day of testifying by our client, their client. This may be a long day of testifying for a therapist. This is where everybody brings in everything they want to say about the other party. But like you were saying, Christy, it is an expensive day to tell your story. It's a very expensive day. And at the end of the day, the court is highly unlikely going to give you 100% of what you want or give your spouse 100% of what they want. A lot of times the anecdotal story that judges will tell us lawyers is, after I give my ruling, if both parties look upset, I know I've done my job well. So that's how the judges are coming in when they're making your rulings. And I would caution anyone who is going to final trial, believing that there is some sort of justice going to be done for them. Because what is justice, right? To your client and your client's perspective, it may be 100% different than what the other party is thinking, what the judge is thinking, because the judge is really just trying to focus on what's best for these kids. And then, oh, I'm going to do a little bit of math on the money, like, and figure out who gets what. That's just a math question. But between on the custody things, I'm going to try to figure out what's best for the kids. And that may not be consistent with what your client thinks is best for the kids. And oftentimes, like I said, they're going to do something in the middle, which then your client or the other side will be upset about, depending on what issue it is. So this is always a really tough thing to go to final trial emotionally, but also the results of that, not having power, not having a choice, and giving that choice to somebody else makes things really difficult. And oftentimes, if you're at final trial, probably going to see you in litigation again for a modification or an enforcement lawsuit, so brand new lawsuits, because you're unhappy about the results because you didn't make those choices. You let somebody else make those choices. And so final trial is not only expensive, but it is a really tough day for the clients.
One other thing I would add on that, and that I want to make sure we mention too, because I think it's helpful if you're somebody that is required to come and testify, you don't always go forward on that day. So which makes it even more expensive, right? So your client is ready. Okay, we're set for trial. We get there, we see that there's 3 other cases that are there. All scheduled at the same time. So what our judges do, they don't just set one case for one day at one time. They pack it full, to 5 to 10 cases, because their expectation is that some of those cases will settle and not go to final trial. Or maybe I will just need a little bit of time for this case number 1, and then a little bit of time here. But, and they don't, a lot of times, some do. The court doesn't contact us the day before and say, hey, I don't think you guys are going. We get all ready, have our witnesses there. Our client has spent a lot of money, especially with third-party witnesses that they needed to pay. And then judge may look at them and say, sorry, I need to reset you. Or just, sorry, I'm taking vacation today. That has also happened. So that's very frustrating and upsetting. We totally get it, but that's another thing we have to explain to our clients of, hey, even though you're set for trial, we have to prepare as if you are going to trial, but you may not, and it may be reset for another 3 months after that. So
And then
that's
reset
really,
again. Yeah.
yeah,
So
that's really hard.
if you're the third party person being subpoenaed and you're paid to be there, make sure you have a rescheduling policy. And I would highly recommend that policy not be, your retainer is gone, now you have to have a new retainer. And I say that just because it may make business sense, but it is not kind, because a client has no control over that judge. Clients have no control over that judge.
And then what I'd also say is, sometimes Reagan's going to laugh about this. Sometimes we have final trial and the judge will not issue a ruling right then and there. They say, I'm going to take it under advisement. I'll let you know my ruling when I have that. And months will go by. I mean, we're talking about not, a month. No, we're talking about 6 months, sometimes longer, where we still don't have a ruling from a judge, and we're having to very politely ask, hey judge, just wanted to see, how are you, just checking in on that, just wanted to make sure I didn't miss anything. It's very frustrating when that happens for the client, because they're just in limbo. And so kind of going back to what we talked about earlier, just kind of to explain more. So if there's not been a ruling on final trial, that means you're still living under temporary orders. So you're still living under temporary orders until there is a final ruling. So that's when those temporary orders become so important. And also just to let you know, on temporary orders, a lot of times we only get 20 minutes per side to present our case. And these people live under these temporary orders for that entire time until a final ruling.
So I have a question. Is the final ruling when the judge says stuff, or is it when he signs the orders?
So normally it's when they say something, or normally they're not just saying something. Sometimes they do. But a lot of times they'll issue what's called a memorandum ruling. And
Okay.
it'll be handwritten or typed up, and that will be the date of their ruling. And a lot of times they'll grant the divorce on the day of the trial, but and sometimes they won't. So that's fun. And then sometimes it's later on when they're issuing the ruling. And so then that goes to, I think what you're talking about a little bit is the final divorce decree. So let's say that the judge issues his or her ruling from the bench, or this memorandum, that's in writing. We have to then put that into a formal document that's called a final divorce decree that has all of this order language, and it's very formal. We have to put that in there. And then once the judge signs that, that is when everything is completely finalized. Like, that is the end all be all document. Going back, not to be too confusing, but going back to when we talked about mediation and how Reagan was talking about, hey, you can resolve your case through mediation. There will be a document that comes out of that mediation that, if everybody reaches an agreement, that everybody signs. That document still has to be turned into a final divorce decree. So a lot of people think, oh, I either got a ruling by the judge verbally, or, oh, I got this mediated settlement agreement. That's not your final document. You still need this final divorce decree to be signed off on by the judge, that then you can go send out to third parties and things of that nature, like for accounts and stuff like that.
But once the ruling is in effect, that's in effect. Like when the judge
Correct.
says, this is my decision on things, even if we don't have the paperwork done yet, that's what you live under, is what the judge said on that day.
Okay, so we have 1 minute, and I know that the next section could be 20 minutes. So
No, I mean, the next section we don't really need to talk about. It's just kind of, we just tell our clients, hey, we're still here for you, even though your divorce is finalized. So if you've got co-parenting issues, or we need to transfer assets in your spouse's name into your name, oh, I need a financial advisor, I need a therapist, like we need a parent facilitator, we just make sure that they understand we're always here for them, even though their case might be concluded. And there might be some things just once that divorce decree is signed, that's still just like from the financial side that needs to be tied up. And we do that unless the clients say, no, I will handle it. And we say, absolutely, you can do that. 100%. You take it. So yeah.
Thank you so much. Okay, I would ask questions, but I don't really have any. You guys were very thorough. I have to say, this seems like a training. I could envision this particular thing going into a 6-hour training with you and me and Marianne Kildebeck. I just think that we could really make a great thing there. We'll see if there's a desire for that. And if there is, please email me and let me know if you guys want these two amazing attorneys and someone from Acorn to come to your place and talk about the divorce care process, or if you would be interested in getting CEUs from us, that would be awesome as well. Anyway, thank you, Rebeccah. Thank you, Reagan. You guys are amazing. I appreciate you so much for taking the time on a Friday. Bye-bye.